Hi, friends. I'm Sharon Abaud, immigration attorney in Los Angeles, California. I'm here today for our weekly show, Ask Sharon, where I answer all your immigration questions. I'm here every Tuesday answering your questions live at 6 p.m. Pacific time. And I'm really excited to be here. Every week has been a bigger and bigger turnout. I think this is our third week now, so I'm super excited. And for our Spanish listeners, I do have a show every Thursday at 6 p.m. Pacific time. I just want to give a general warning. I cannot give individualized legal advice on this channel. There's no way for me to know everything or ask all the important questions that I would need to know to provide you with legal advice for your particular situation. Also, I wouldn't want you putting out all your personal information out here because it is a public forum. So if you do want advice on your individual case, I suggest that you book an appointment. But if you have general questions, this is the place for you. I also want to let you know that I have a YouTube channel where I do go into depth about different immigration topics. I upload videos pretty regularly and try to educate the immigrant community that way as well. So I do have questions from my recorded video last week that I would like to answer. So someone wants to know, they say, I filed an I-130 for my wife. I am a resident. Since the F2A is current, can she file for adjustment of status? So first of all, there are a lot of things that I don't really know here. I would need to ask this person a lot of questions, but to get started, for those of you who don't know, the F2A is the category for the spouses of residents. So if you are married to a resident, unlike a citizen, you are going to be sort of, put on a wait list. So you're going to have to wait for a visa to become available to you. Now, something really exciting happened this summer and is still on right now. What happened this summer was that category became current for all countries and, all categories. So people who are married to a green card holder, if you file now, your visa was supposed to be immediately available. And immigration also said, for those of you who qualify, you can also file for adjustment of status. And what is adjustment of status? It's the application for your green card that you can file here in the United States. So there are some caveats that someone married to a U.S. citizen wouldn't face. For example, if you are married to a green card holder and you want to adjust your status through the resident spouse, you have to be in lawful status. So you can't be in a situation where you're, let's say you came in here on a tourist visa and your tourist visa expired. If it's expired when you file, you're not going to qualify for adjustment of status. Now, let's say that you do qualify for adjustment of status because you are still in status. That doesn't mean you qualify. There are still other reasons that you might be inadmissible or that you might not qualify for adjustment of status. This is why I always recommend that you at least consult with an immigration attorney to know, exactly where you stand and to make sure that you qualify. You wouldn't want to learn the hard way that, you went through all this work and then you get denied, and then even worse, you are placed in immigration proceedings. So always be safe. Better to be safe than sorry. And let's see if I answered your question. Can you file for adjustment of status? So yes, that totally depends on the situation. I don't know in this question if, I really don't know if this person is still in status. And I also didn't ask them all the other questions I would need to know to make sure they're not inadmissible for some reason or ineligible for adjustment of status. So that is that. And then I have another question. Will the new policies, this is, I think, the most popular question as of recently. Will the new policies regarding public charge affect me when I file for citizenship? So this is really common. This person is referring to the new policies, the public charge policies. If you haven't heard of them yet, public charge it's not new. It's been a ground of inadmissibility for a while now. What has changed, though, is how they define who is likely to become a public charge. And so, that has changed. It's created It's made it easier for people to fall under the category of likely to become a public charge. And if immigration finds that you are likely to become a public charge, they can find you inadmissible and deny your case on those grounds, making people, really nervous. And so we definitely want to make sure that, if you think there's an issue, you definitely want to talk about those issues with your immigration attorney. But will it affect this person who wants to know if it will affect their citizenship? So I'm assuming this person's already a resident. And they're waiting for maybe, let's say, the 5 years to become a citizen. If that's the case, then this shouldn't affect you. We haven't heard anything, at least yet, where being a public charge would affect someone who is about to become a citizen. This only affects people who are trying to become residents and also non-immigrant visa holders. That would be my answer to that question. And then I also have a question. I am a U.S. citizen. Can I file for my dad? So this is a very broad question. This would really depend on a lot of things. First of all, I don't know the person's age. You must be 21 years or older to be a U.S. citizen filing for a parent. I also don't know if this parent is inside or outside the U.S. If they are outside of the U.S. and they don't have any inadmissibility issues like public charge, for example, or any crimes or other reasons that might come up, then they would just process outside, and likely, if they don't need a waiver, then it'll just be the petition and the immigrant visa processing through an embassy. They would be scheduled to get an interview abroad, and that would be that. If they're inside the U.S. and the person wants to know if they can file inside, that would really depend, again, on their situation. I strongly advise this person to get a consultation. If it's the case where the person does not have a way to adjust status, the parent, we oftentimes face a dilemma in this situation because they will have to schedule an interview. They'll have to leave the United States and go to an interview abroad. Now, what happens when they leave for an interview abroad? They trigger unlawful presence, and for that, they need a waiver. In this case, if they don't have the qualifying relative for the waiver, they're not going to be able to file for the waiver here. They're going to have to go to the interview, get denied, and then file a waiver. This can be years. And then, assuming the waiver gets approved. So this is definitely a situation where you want to consult with an immigration attorney and make sure that you understand, your situation well, and you know what's going on. And this is the case because the child, if you're the child or you're the adult child petitioning for your parent, your relationship to your parent won't qualify. They won't qualify based on having a U.S. citizen child for that waiver to file here in the U.S. The only way to qualify for that waiver is having a U.S. citizen or lawful permanent resident spouse or parent. And so if they don't have that relationship with anyone, then they're not going to qualify for that waiver, and they're going to have to spend a lot of time outside of the U.S. to be able to get their green card that way. So this is definitely something you need to be aware of. I've seen it often where people think it's easy breezy and they just, do it on their own or have a friend help them based on their experience, and they can get into trouble here because things can get complicated. And I want to remind everyone here that this is a place where you can ask me a question. It's awfully quiet today, and that's fine. I have my questions here that I'm sharing and hoping that it benefits someone out there, because I know that you guys later also watch this recorded, and I know that it helps a lot of you answer your questions. So that makes me really happy. And I want to take this time before I go on to the next question to remind you that I'm here every Tuesday at 6 p.m. Pacific time. I'm here live answering immigration questions. And yeah, I'm super excited to be here. And I also have a wealth of information on my YouTube channel. If you subscribe, I upload new videos pretty regularly, and you can learn a lot there. I do remind you that this is not a place to get individualized legal advice. I cannot advise you on your particular case because there's no way that I'll learn about everything I need to know about your case in this public forum. I would need to speak to you individually and ask you all the important questions to be able to really give you legal advice. Please keep that in mind when you ask questions, that I'm not giving you particular legal advice. And so now that I've said all this, I'm going to move on to my next question. My husband is sick. He is petitioning for me. My case has taken a long time and my husband is in critical condition. We have 2 kids. I'm so worried and scared about losing my husband and also having to relocate with my kids. I'm really, really sorry to hear about this. I know that times are rough and the last thing you want to worry about is having to move your family because you're worried that you're not going to be able to have a petition approved for you. And I know that you're dealing with, potential loss in your family, and I know that that's going to be rough, and you certainly don't want to have to deal with this. So I do have some good news for you. Even in the unfortunate event of his passing, there's still a way that an immigration attorney can help you. But you won't have all the time in the world. You do want to act quickly. It's only about 2 years you have to file for this type of relief after a spouse has deceased. It wouldn't be gone 100%. There would still be a chance for you to stay here with your kids and not have to deal with the stress of relocating with your family. Thank you for sharing that, whoever asked. That was a really touching question, and I hope that you are watching this out there somewhere and that you received the answer that you wanted. But definitely, keeping you in my thoughts and hope everything turns out okay. So I am Sharon Abaud, immigration attorney, here every Tuesday at 6 p.m. This is our week number 3 here on Facebook Live, and I think this has been our most quiet Facebook Live event. I think everyone's recovering from the Labor Day weekend. And that's totally fine because I know that you guys are all going to watch this later and you're going to hear some information that hopefully benefits and helps you. I'm super excited to always, to help in any way that I can. I also have a YouTube channel that you can subscribe to. I upload new videos pretty regularly where I provide regular information. I also want to put it out there for those of you who do want a one-on-one consultation. My phone number is 310-803-3040. I have it in my description. It's 310-803-3040. You can also schedule an appointment online. It's super easy. You just go to my link, which is up there. It's aboutlegal.com, and you just click on schedule an appointment now. And that is how easy it would be to speak to me one-on-one and see if you have a case, and I can answer all your questions. And so, today is really quiet, shockingly quiet. So I think we're going to keep this video pretty short. I can't wait to see you guys next week. I know it'll be a normal week next week and that we're going to be talking the whole time. And I am, again, Sharon Abaud, immigration attorney, and I will see you here next week. Thank you.